Good afternoon, ladies and gentlemen, dear participants, to this ICSID regional training event held in Bangkok and organized jointly with ITD. My name is Joubin Bret. I'm the Secretary of Untitled, and it gives me great pleasure. It's an honor for me to be included in this program and to be given this opportunity to present the Untitled reform process. Untitled is the United Nations Commission on International Trade Law. It was established more than 50 years ago as a commission of the United Nations General Assembly. Untitled works on the basis of a mandate to further the progressive harmonization and modernization of international trade law. Untitled is a place where legislative reform is undertaken and international instruments are prepared either in the form of international conventions such as the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards, or the more recent Singapore Convention, opened for signature in Singapore last month and to which 46 countries have already signed on, with a couple more countries in the pipeline for the treaty days in New York. But we don't only develop international conventions, we also develop model laws, we also develop legislative instruments, legislative guides, guides to enactment, rules, and different documents and instruments that are available to countries to further the reform and the harmonization of international trade law. Untitled also promotes the use and adoption of these instruments, as well as their interpretation and their implementation in its technical assistance activities that it carries out all over the world. And we had the pleasure of working together with the government of Thailand in various areas, including secure transactions and also insolvency. In short, Untitled is a legislative body of the United Nations system, like the International Law Commission, and a core organization in the field of international trade. Being an organ of the General Assembly, the methods of work of Untitled are generally similar to the ones of the General Assembly. Its sessions are open to all states, members of the United Nations, and international organizations are also accredited and invited to take part in the sessions as observers, where they can also contribute their particular expertise. The Commission organizes its work in working groups that prepare the instruments that are brought to the Commission for adoption, and these working groups are tasked with a particular topic or a particular project of legislation. Untitled currently has 6 working groups. One of them, Working Group 3, is working on the topic of ISDS reform, and this is what we want to discuss together. The sessions of the Working Group 3 have been attended by around 400 delegates from all regions, representing more than 110 states and 70 international organizations. The reform of investor-to-state dispute settlement system in Untitled is considered from a generic and holistic point of view. What I mean by that is that Untitled is not working on the revision of its arbitration rules or adding features to the existing international arbitration system, such as is currently undertaken by ICSID in its amendment project, and no doubt my good friend Meg Kinnear has presented to you in detail. Similarly, Untitled does not offer a policy discussion forum such as UNCTAD to exchange experiences and best practices, and I leave it to my former colleague Elisabeth Türk to explain in greater detail what UNCTAD is doing. Untitled's approach is wider in the sense that it works towards reforming the ISDS system as a whole. The unique element of the current process at Untitled is that states gather to consider actual reform to the ISDS system as a whole. And that said, it's too early at this stage to tell you what the outcome of the deliberations will be and what the final reform will look like, because the range of possible reform options on the table is quite wide. But I will go back to that in greater detail later in my presentation. The ISDS regime was developed as part of the investment promotion and protection regime to allow a foreign investor to bring a claim directly against the state as a way to depoliticize disputes and allow a neutral settlement of the dispute. This regime constituted a significant development as traditionally diplomatic means, i.e. the espousal of a claim by the host country of the investor, were used for the settlement of disputes relating to investments. It's important to keep this historical dimension of ISDS in mind when thinking about reform. Clearly, the system we have in place today is the result of historical and economic realities of the 1960s, and we are today, in 2020, no longer in the same situation. In addition, this dispute settlement mechanism has come under considerable criticism. Improvement of the regime is therefore important as the number of investor-state disputes is rising and there is considerable potential for more disputes. Think, for example, about the massive infrastructure investments that come with the Belt and Road Initiative, or simply with the growing need for energy sources or raw materials. By the end of 2018, 942 known investor-to-state, treaty-based investor-to-state arbitration cases have been reported by UNCTAD, involving 117 countries as respondents. In some 2/3 of the cases, the respondents were developing countries or economies in transition. Now let me talk a little bit more about the UNCITRAL mandate on ISDS reform. The instruments developed by UNCITRAL in the field of international arbitration are generic and applicable to commercial as well as investment arbitration. This is true for the New York Convention, the model law, and the arbitration rules. However, for the first time in 2013, UNCITRAL adopted an instrument applicable to ISDS only and specifically, the UNCITRAL rules on transparency. The rules on transparency are procedural rules that provide for transparency and accessibility by the public to treaty-based investor-state disputes. The rules on transparency have been incorporated in most investment treaties concluded since their coming into force. In addition, UNCITRAL prepared the United Nations Convention on Transparency in Treaty-Based Investor-State Arbitration, also known as the Mauritius Convention, which entered into force in October 2017. It provides a mechanism for states to consent to the application of the rules on transparency to investment treaties concluded prior to their coming into force. And this is the interesting feature of the Mauritius Convention. In essence, the Convention introduces the substantive transparency standards of the transparency rules into a fragmented treaty-by-treaty regime by way of a single multilateral instrument. It's also a flexible regime as it foresees limited number of reservations only that contracting parties may formulate. On that basis, and given UNCITRAL's specificities and experience, UNCITRAL has decided to consider whether the Mauritius Convention on Transparency could provide a useful model for wider possible reforms in the field of investor-state arbitration. And this is so that at its annual session in 2017, and based on background studies and wide consultations, UNCITRAL was given a mandate, or UNCITRAL mandated a working group 3, to work on possible ISDS reform. Working Group 3 has been given a 3-part or 3 stages mandate to engage in deliberations that should be government-led, consensus-based, and fully transparent. This mandate, this 3 stages mandate, begins with a first stage to identify and consider concerns regarding investor-state dispute settlement. Second, to consider whether reform was desirable in light of any identified concerns. And third, if the working group were to conclude that such reform was desirable, develop any relevant solutions to be recommended to the Commission. The working group was further given broad discretion in discharging this mandate, and any solutions would be designed taking into account the ongoing work of relevant international organizations, such as ICSID, the OECD, or UNCTAD, and with a view to allowing each state the choice of whether and to what extent it wishes to adopt the relevant solutions. Now, as far as the ISDS reform process is concerned, we started with the first stage of the mandate to identify concerns and work on or take decisions as to the possible reform. The first 2 phases in the ancestral reform process, which are first to identify the concerns and to consider and discuss them, and second, to consider whether reform is desirable in the light of these identified concerns, have been completed already, with the understanding, of course, that any additional concern can always be raised and will be considered by the working group. This is not a limited, closed list of concerns on which states have agreed, but rather it is an inventory that is open for further consideration. So now, what are the concerns identified that form the basis of the reform agenda? The first broad category of concerns that the working group discussed relates to costs and duration of investor-state arbitration proceedings. The working group agreed that it is desirable to develop reform to address concerns with respect to generally the costs and the duration of ISDS proceedings. And I'm sure that during her presentation, my friend Meg Kinnear has explained what the issues are when it comes to streamlining the process. Second, how the costs are allocated between the parties by arbitral tribunals. And third, security for costs. The second broad category of concerns the working group discussed relates to consistency, coherence, predictability, and ultimately correctness in arbitral decisions by investor-state tribunals. The working group agreed that reforms should be developed to address concerns with respect to 3 subjects related to this broad category of concerns. First, the fact that unjustifiable, inconsistent interpretations of investment treaty provisions and other relevant provisions or principles of international law by ISDS tribunals have occurred and could continue to occur in the current system. Second, the lack of a framework for multiple proceedings that are brought pursuant to investment treaties, laws, instruments and agreements, for example, contracts concluded between investors and the state that provide access to ISDS mechanisms. And third, the fact that many existing treaties have limited or no mechanism at all to address inconsistency and incorrectness in decisions, which means does not allow for an appeal or a review of the outcome of the awards. The third broad category of concerns that the working group discussed relate to arbitrators and decision makers in ISDS proceedings. The working group agreed that reforms should be developed to address concerns with respect to the lack or apparent lack of independence and impartiality in decision makers in ISDS proceedings, the adequacy, effectiveness, and transparency of the disclosure and challenge mechanisms available under many existing treaties and arbitration rules, the mechanisms for constituting ISDS tribunals in existing treaties and under arbitration rules, and the lack of appropriate diversity amongst decision makers in ISDS. The working groups also discussed concerns about third-party funding, and it decided that it was desirable that reforms be developed in order to address concerns relating to the definition, the use, or possible regulation of third-party funding in ISDS. Now we come to the development of reform options, what we are doing, what the working group is doing currently. The stage of the reform process we are at now is to decide how to organize the work in phase 3, which is the phase where actual reforms will be discussed. The working group already agreed that it would discuss, elaborate, and develop multiple potential reform solutions simultaneously. So it's not a sequence of reforms, but it's various streams that are being managed and being discussed in parallel. The focus of the work is on concerns with respect to ISDS, rather than the more general topic of international investment agreements reform that my colleague of UNCTAD will no doubt present, which includes also reforms to the substantive rules in international investment agreements, not just to the dispute resolution procedures. That does, however, not diminish the importance of answering questions about reforming the substantive provisions in international investment agreements. And you will agree with me that it is a whole. The rules and the substance form a whole. The approach that was taken in UNCTAD was to tackle first the dispute settlement mechanism, which crystallized most of the criticisms about the current investment promotion and protection system. However, these rules have an impact on the substance and on the way, ultimately, states keep control over the instruments they negotiate and how these instruments are being applied in practice. Now, how are we proceeding with the reform agenda? The first step was to identify additional solutions or to listen to proposals or to table proposals by states. As I mentioned, the reform agenda in the Working Group 3 is government-led. It is state-led. It is not managed by a secretariat, as is the case in the ICSID amendment process. It is not pushed or promoted by a group of countries. It is simply open for states to table their proposals, and states including from the region Indonesia, Thailand and Japan, jointly with Chile and Israel, China and Korea have already submitted their proposals. Step 2, which will occur at the next meeting, will require the working group to discuss all of these proposals that have been received and to create a project work schedule. Step 3, which will also begin at the next session, is that after that schedule is created, the working group will turn to further elaboration and development of potential solutions to be then recommended to the Commission for its adoption, pursuant to the mandate. Proposals that have been received from states for ISDS reform are generally available on the website of UNCTAD in all 6 languages of the United Nations, and are also presented in a document prepared by the UNCTAD Secretariat. UNCTAD did not start consideration of reform options yet and did not take any decision on which reforms should be undertaken. The proposals by states cover the following options, and let me walk you through step by step some of these options with a diagram. First, the establishment of a multilateral advisory center. The idea of a multilateral advisory center to assist parties in ISDS disputes is not a new idea, and it has been patterned, or it is discussed, patterned on the existing and successful advisory center on WTO law that was set up to assist countries in bringing and defending disputes under the WTO system. The establishment of such a center would require considering its possible forms, its possible functions and services, including assistance to states in organizing the defense, support during the dispute settlement proceedings, advisory services, access to alternative dispute resolution services, as well as capacity building and sharing of best practices. The other discussion that needs to take place in relation to this proposal is the beneficiaries, which could consist of all or some states, and which could also be enlarged to encompass access to the system by small and medium-sized enterprises, which was also considered as one of the concerns with the current system. A proposal has been tabled by the government of the Netherlands that has tasked the Columbia Sustainable Investment Center to develop further a feasibility study, as is reflected in the working paper prepared by the Secretariat. A second option that has been tabled is to establish a standalone review or appellate mechanism or a standing appeal system. For instance, in one proposal, it is indicated that most rules used in investment arbitration do not provide for quality control, whereby an award can be reviewed before it becomes final. It's therefore suggested to establish a procedure for the prior scrutiny of arbitral awards, but another proposal, or several other proposals, also advocate the establishment of a standalone appellate mechanism that could be functioning as an appeal system for arbitral awards, for a first instance court as proposed under the multilateral court system, and we will look into this proposal right after the appeal mechanism. The existing domestic remedies, where, for example, for instance, issues of denial of justice could be brought to this appeal mechanism, and it could be regarded as a higher judicial authority tasked with ensuring consistency in the interpretation of the provisions of investment treaties and rectifying errors in awards that could have a significant impact on, or that have a significant impact on public funds. The third proposal relates to establishing a standing first instance and appeal investment court. This proposal was tabled by the European Union very early on, and this court in the European Union's proposal would be manned by full-time judges, professional judges. This is based on the view that the different concerns identified by the working group are intertwined and systemic, and that they would be better addressed in a holistic reform system such as this investment court, rather than addressing specific concerns in a piecemeal approach, which would leave many of these concerns unaddressed. A fourth proposal is to review and reform the arbitrators and adjudicators' appointment methods, and also to develop more stringent rules relating to conduct and ethics. This includes the regulation of the current party appointment mechanism, the establishment of a roster system, the involvement of institutions, the so-called appointing authorities, and or the creation of first instance and appeal investment courts. The different solutions could be looked at under the arbitrators and adjudicators appointment methods. The preparation of a code of conduct is a joint project that we are currently carrying out with ICSID, and that will also be discussed during the working group sessions. Treaty parties' involvement and control mechanisms on treaty interpretation are yet another area where reform proposals have been made in order to address concerns of unjustifiable, inconsistent treaty interpretation. Such reform options would aim at encouraging a more systematic use of unilateral interpretations, but also joint interpretations between parties, treaty parties, and multilateral interpretations, as well as ensuring abidance thereof by arbitrators or adjudicators in the case of an investment court. This reform option might consist in establishing or strengthening the framework for state-to-state preliminary consideration of issues, including technical consultations, decisions by respective state authorities, setting up of a joint review committee by the treaty parties, a review or an appellate mechanism, or a state-to-state body to which application could be made if the claim cannot be settled at the technical level in a given period of time. Another option mechanism is to strengthen the dispute settlement mechanisms other than arbitration and to offer alternatives to the mainstream system, which is currently the use of arbitration. This could be done through the use of ombudsman services or through the strengthening of mediation. This could then reduce, of course, the duration and the cost of proceedings, and if used at an early stage of a dispute, prevent escalation into a legal dispute. Exhaustion of local remedies has been put on the table in several proposals, following the mode of certain investment treaties that include a mandatory requirement to pursue or exhaust these local remedies for the settlement of investment disputes in order to empower domestic legal system and avoid their bypassing. Procedures to address frivolous claims, including summary dismissal, procedures to address multiple proceedings, reflective loss and counterclaims by respondent states, expedited procedures in order to reduce the duration and the cost of ISDS and deal more efficiently with certain categories of claims, principles and guidelines for allocation of costs and security for costs and consideration of other streamlined mechanisms or tools to manage the cost, third-party funding, how to address third-party funding, to regulate it, to ensure greater transparency, also with regard to limitation, disclosure, and costs. All these options are currently on the table, and I'm going to explain to you how this can be further, this is going to be further developed by the Antitrust Secretariat. The preparatory work that Antitrust Secretariat was mandated to do identifies 5 topics, which are also available on the Antitrust website. Everything, by the way, that I'm telling you today is available on the Antitrust website, whether the working papers, the reports, the recording of the working group sessions and the commission meetings, the documents prepared by the Secretariat, everything is there. The working papers that the Secretariat has prepared cover the following topics: a code of conduct that is jointly, that has been jointly developed with ICSID, indirect claims, claims by shareholders and effective loss, where the document draws heavily on the OECD study relating to the same subject matter, selection and appointment of adjudicators, third-party funding, and the establishment of an advisory center on international investment law. Now, another question that the reform process will need to consider as it moves forward is the implementation of these reform options, as indeed multiple potential reform solutions could be developed and will be developed simultaneously. One possibility is the simultaneous implementation of reform options through an opt-in convention that could be modeled after the Mauritius Convention on Transparency that I explained earlier, and the OECD Multilateral Convention to implement tax treaty-related measures to prevent base erosion and profit shifting. This instrument also applies to a myriad of existing double tax treaties developed following the OECD model. The purpose of such an opt-in convention would be to ensure applications of the reform to existing investment treaties and to avoid having to reopen and rediscuss every single investment treaty that is currently in existence. Such a mechanism may be needed in addition to other specific instruments to be developed with respect to reform options. Now, the last point I would like to make is that the working group found it important among the different tools to ensure greater participation and inclusiveness of this reform agenda to also develop intersessional or hold intersessional regional meetings. These meetings are informational and therefore no decisions are made during these meetings. However, they are reported to the working group and have been found so far extremely useful in bringing all countries up to speed to the reform agenda and the consequent involvement of these countries into the working group process. The first intersessional meeting on ISDS reform was held in September 2018 in Incheon, Korea. The meeting in Incheon consisted on a one-day conference providing regional perspectives on ISDS reform, followed by a half-day roundtable discussion aimed at raising awareness in the Asia-Pacific region of the current work of the working group, as well as providing an opportunity to reflect on regional experiences with ISDS. This was quite early in the reform process, and it basically took stock and centered around the concerns. It was attended by 191 participants, including government representatives from 34 states. The second intersessional regional meeting was held in February 2019 in Santo Domingo, in the Dominican Republic, which was equally very successful. At the APEC Investment Expert Group meeting held in August 2019 in Chile, we also updated APEC on the progress of Working Group 3. A third intersessional regional meeting on ISDS will be held in Conakry, Guinea, between the 25th and the 26th of September 2019. This event is jointly organized by the Government of Guinea, our host, and the Organisation Internationale de la Francophonie, and UNCITRAL, and it will bring together high-level representatives of governments, stakeholders, and experts from Africa. It aims to provide an open forum for discussion and for discussing the ISDS reform from a regional perspective, but focusing more now on the solutions that are on the table. What are the next steps? The next steps are the next session of the working group, which will hold its 38th session from 14th to 18th of October in Vienna. The annotated agenda is published on the UNCITRAL website, and in this session the working group is expected to continue its consideration of ISDS reform based on the working papers prepared by the Secretariat as well as the proposals submitted by states. The next session will take place again in Vienna from 20 to 24 of January 2020. It is an additional session that was agreed by the Commission given the workload of this working group, and then the next session will follow in New York as usually scheduled. In conclusion, There is a variety of possible reform options that are on the table for the state's consideration. There are fundamental differences in some of the reform solutions that are being proposed and in the approaches to tackle the concerns identified. Some of these options are more structural in nature, some involve reforms within the current system, and some straddle that line. The working group agreed to discuss, elaborate, and develop multiple potential reform solutions simultaneously. For that purpose, it will continue to prepare a project schedule to move the possible solutions forward in parallel. Stay tuned to the next developments. Thank you very much for your attention, and I hope to see you in Vienna or New York soon. Thank you. Bye-bye.